Tonight, we're diving into a case before the U.S. Supreme Court that could have major implications for workplace discrimination lawsuits. To break it all down, we're joined by Elie Mystal, justice correspondent for The Nation. Elie, I'm a great fan of your work, and I really want to thank you for being here. So for those who may not fully be aware, can we start with the bigger picture? How significant is this case, and what impact could it have on future discrimination lawsuits?
Okay, so I'm going to kind of answer the question two ways. It's very significant, but I actually don't think it will have a huge impact on the future of anti-discrimination lawsuits, at least if the case kind of stays the way that it seems to be going from the Supreme Court. So that's a little bit complicated. So let me start with the actual lawsuit, all right? Marlene Ames is a straight white woman who claims that she was passed over for promotion when they hired a gay person for the job. And that's it. That's her entire evidence. No pattern or practice or history of racial or sexual discrimination, no larger background issues. It was just she wanted the job and they gave it to a gay person. So clearly she was looked over because of her heterosexuality. If white fragility could be a Supreme Court case, this is what that case would look like, right? Now, everybody out here knows you can't bring no discrimination lawsuit if all you got is that they promoted a white man ahead of you, right? No black person can do that. If we could, we'd have a lawsuit every Tuesday, right? So we understand that you need to bring more evidence than just they hired some other person that doesn't look like you for the job, or else, again, discrimination lawsuits would be all over the place, right? So now Ohio is a very special state in terms of it's how federal law applies there. It's one of the only states, there are like a couple of them, that have this very archaic rule, judicial rule for civil rights complaints. Now, obviously, anybody, white, black, brown, green, whatever, can sue for racial or sexual discrimination. But in Ohio and a couple of other states, if you are a member of the majority, which usually means white, in this case means straight, you have to show a background pattern or practice, right? You have a heightened standard of proof to bring a racial discrimination case, right? This makes sense if you think about it, right? If I'm black and I'm suing for racial discrimination, I shouldn't have to prove that racism exists, right? Like we can skip the remedial white history part of the class and just go straight to my individual complaint, right? But if you're white, since, this country does not historically discriminate against you, since this country does not historically discriminate against straight people, then you kind of have to prove that there is something else in the history of your organization or institution that points towards discriminatory behavior before you can bring a civil rights case, right?